A fire in the early hours of the morning destroyed a small electronics factory on the Fulchester Industrial Estate. The building was heavily insured. Was the fire accidental, or did someone deliberately set out to burn down Scott Specialist Electronics? Hugh Scott, an ex-RAF officer and managing director of the company, is on trial in the Crown Court today. The charge is arson.
Scott Electronics is a small company on the Fulchester Industrial Estate.
What time was the alarm given?
At 3:27 a.m., my lord.
So when you received the report on the fire from the fire department...
Oh, just a minute. Should we be hearing from a fire officer?
Oh, yes, my lord.
Oh, yes.
Inspector, what did you do after you received the report on the fire?
I went to see Mr. Scott. I told him the report suggested that the fire had been started deliberately.
And what did he say?
He said, I didn't do it, I was in London.
But had you suggested that he was in any way responsible?
No, madam, just that someone had.
And yet he said, I didn't do it.
Yes, madam.
Yes. Continue.
I asked him whereabouts in London he'd been. He said he'd been with Mr. Broom, his solicitor. They stayed at the Edwardian Hotel, Jermyn Street.
And did you ask where they had been at 3 a.m.?
Yes, madam. He said they'd been in various clubs in Soho. From approximately 1 a.m. to 2 at Blue Giraffe in Dean Street, and from 2 a.m. to 3:30 they were at a club called Drawers in Frith Street. They were back at their hotel by 3:45.
And you checked all that?
Yes, madam, it was all correct.
So that on the face of it, Mr. Scott had a foolproof alibi. He wasn't there when the fire started.
Yes, madam.
Now, after you'd seen Mr. Scott, did you receive a second expert's report?
A second report, Miss Gibson?
Yes, my lord. It's in the second bundle of documents. I shall be calling this expert as well.
The first report suggested that the cause of the fire was electronic failure, my lord. So an expert was called in and he examined the debris after the fire.
And, Inspector, what does the second report show?
It explains the way in which the fire could have been started electronically.
By whom?
By Mr. Scott.
Although he was in London at the time of the fire.
Yes, madam. All that was required was a single phone call.
Where to?
To Scott Electronics. All that was needed was that the phone should ring, and this would set off the device which caused the fire.
I shall be demonstrating how this device works, my lord. Inspector, did you ask Mr. Scott if he had made such a telephone call on the morning of the fire?
Yes, madam. I saw him and Mr. Broom together. I asked him if he'd made a telephone call that night. Now, Scott said no, but Mr. Broom said that wasn't entirely correct, that he and Mr. Scott had not been in each other's company for the entire evening. They'd made several separate trips to the lavatory, and on one occasion, Mr. Scott had gone to phone a woman he used to know in Ealing. She turned out not to be in. I asked Mr. Scott what the telephone number was, and he gave it to me.
And you checked on that telephone number?
Yes, madam. It turned out to be that of a bank.
A bank? But did Mr. Scott explain his mistake?
He said I must have been drunker than I thought.
Now, did you find any motive that it might have inspired the accused to commit arson?
I said, I believe the factory is insured with the Bristol and Guildford Industrial Fire Insurance Company. He agreed it was. I said, I believe that 2 months before the fire, you increased the cover from 95,000 to 135,000. Is that correct? He said, yes. So
that in the event of a fire, Mr. Scott would have made £135,000.
That is correct, madam.
Now, Inspector, what is Mr. Scott's background?
He was in the Royal Air Force, an engineering officer specializing in electronics. He left the RAF and he started his own business 8 years ago. It was very successful until last year.
When first you charged Mr. Scott, did he say anything?
After I had cautioned him, he said, bloody A-levels, it's ruined the game for everybody. Everyone's an expert nowadays.
Thank you, Inspector.
Inspector Owens, what did you think Mr. Scott meant by that remark?
I took it to mean he was complaining that the job of the arsonist had become more difficult because fire officers were becoming more educated.
What? You mean you didn't realize he was referring to you?
Me, sir?
Well, you were cautioning him, weren't you, Inspector?
Yes, sir, I was.
I mean, you didn't appreciate that what Mr. Scott meant was that because of education nowadays, even detective inspectors were beginning to sound like lawyers.
That was not my impression, sir.
Ah, I see. Well, now, Inspector, I am aware that you're not an electronics expert, but could you explain briefly how the fire started?
Yes, sir. Some electronic equipment was left switched on overnight. One of them overheated, thus causing a fire.
I see. It's right that Scott Electronics employs a fair number of people with advanced electronic knowledge.
I presume so, sir.
Where is this leading us, Mr. Canty?
To my next question, Your Lordship.
I trust it's relevant.
It is, my lord. It is right, Inspector, that the police had been called out to the factory before, hadn't they?
Once or twice, yes, sir.
For what purpose?
There was trouble there.
What kind of trouble?
Labor trouble.
Oh, yes, what?
Mr. Scott is something of a perfectionist, my lord. He tends to hire and fire rather a lot. At least two of his workforce did not appreciate his approach to labor relations. There was a fight.
Between whom?
Between Mr. Scott and one of the employees he just sacked, my lord.
It came to fisticuffs, did it?
Apparently, yes, sir. According to the police officer who answered the call.
Now, where in the factory did these men work?
In the laboratory and the testing department, sir.
Indeed. They were electronic experts.
Well,
Weren't they, Inspector?
I presume so, sir.
No. Do you know, was it a common occurrence for Mr. Scott to brawl with his employees?
No, I don't know, sir.
But in the last 2 years, the police have been called out to Scott Electronics 3 times, haven't they, Inspector?
3 times? Yes, I think that's correct, sir.
Because Mr. Scott was having trouble with his employees?
No, sir, not every time. On one occasion, Mr. Scott reported the theft of some electrical equipment.
Oh. What kind of equipment?
Transformers, tuners, that kind of thing.
The kind of equipment, in fact, probably used to cause the fire.
I am not an expert in these matters, sir.
Quite, Inspector. Quite. Now, Scott Electronics is not a unionized firm, is it?
No, sir.
Yes. Well, do you know why not?
With respect, sir, I think that's a question for Mr. Scott.
But you asked him that very question, didn't you, Inspector?
Yes, sir, I did.
Yes. Well, what was his answer?
He said he didn't believe in unions. He wouldn't have them in his factory.
Well, was this the cause of some of the labor troubles he had?
I couldn't say so.
Now, in your investigation, Inspector, did you question all Mr. Scott's employees?
Yes, sir.
His present employees?
Yes, sir.
Well, did any of them complain that Mr. Scott didn't allow unions?
1 or 2, yes, sir.
Did you discover that any of Mr. Scott's employees had the necessary electronics knowledge to create a device to start a fire?
Yes, sir. 21, sir.
21? I see. Now, the device was triggered off, I think you said, by a phone call.
Yes, sir.
Do you know whether any of these 21 people made a phone call that night?
No, sir.
You don't know, Inspector?
No, it was impossible to establish.
Precisely. Now, did you include in your inquiries any employees who had worked for Mr. Scott in the past?
Yes, sir. They'd all worked for Scott during the past year.
How many of them did you interview?
10, sir.
And these included the men Mr. Scott had brawled with?
Yes, sir. They'd all worked for him during the past year.
Were you satisfied with their alibis?
Yes, sir.
Can you be sure that one of them didn't make any phone calls that night?
No, sir.
Quite. Yes. There wouldn't necessarily be any record of the call, would there, Inspector?
No, sir.
No. Yes. Now, were you aware, Inspector Owens, that prior to this fire, Mr. Scott had asked for police protection?
Yes, sir.
When, do you know?
6 weeks before the fire.
Precisely. And do you know why he asked for this protection?
He said he was expecting trouble from some of the men he just sacked, sir.
What kind of trouble?
Sabotage of some sort at the firm, or theft of vital parts. He wasn't very explicit.
Exactly. And he mentioned the possibility of arson, didn't he?
No, sir. Not that I know of.
Well, didn't the police consider it?
Oh, yes, sir. A police patrol car called at the factory three or four times each night.
Did it call on the night of the fire?
Yes, sir.
3 or 4 times?
No, sir.
Why not?
Because after a month, during which time nothing happened, we were forced to reduce the frequency of the patrol. The police at Fulchester are considerably
Inspector Owens, all I want to know
understrengthened.
is how often did the patrol car call on the night of the fire?
Twice. At 10 p.m. and 1:30 a.m.
When did the fire start?
I'm not sure. It was reported at 3:27 a.m.
So, it seems Mr. Scott was correct when he anticipated trouble. Thank you. No further questions.
Inspector Owens, in your opinion, the accused did have an opportunity to set up the device which started the fire?
Yes, madam.
Now, when did he have this opportunity?
On the evening before the fire, madam. He was the last one to leave the factory. He was there for an hour after everyone else had gone.
Fee lawyers.
You are Ernest James Hewlett
Yes, madam.
of 26 Glanbourne Mansions, Fulford,
Yes, madam.
and you are in the fire service.
Yes, madam.
What rank do you hold?
Divisional officer. I'm a fire prevention officer with the Fulchester Brigade.
Now, you inspected the scene of the fire at Scott Electronics, and you wrote this report on it.
Correct, madam.
Members of the jury, you'll recall that this is one of the reports that the accused was confronted with by Detective Inspector Owens. It's in the first bundle of documents, my lord. Inspector Divisional Officer Hewlett, were you able to establish where the fire started?
Yes, madam. The seat of the fire was here in the laboratory where the electronic apparatus was tested.
How can you be sure of this?
From the way in which the wooden joists of the roof were charred. It's what we call the arrow theory, my lord.
The arrow theory?
Yes, let me show you. Now, these are the joists. Now, when I inspected these after the fire was out, this area here had been burnt away, leaving these charred points of wood. Now, from the direction of these points, we know that the fire must have been started in the laboratory.
Can you tell when the fire started?
It can be worked out, my lord.
Oh.
Ordinary timber chars at the rate of 1/40th of an inch in a minute, so all you have to do is to measure the extent of the charring.
So, on that basis, when do you estimate the fire started?
Oh, sometime after 2 a.m., 2:15, something like that.
So that by the time the alarm was finally given at 3:27 a.m., the fire would have had a very strong hold.
Oh, that's right, madam.
Now, what are the features which suggest to you that this fire was started intentionally?
Two things, madam. The presence of heavily charred wood wool, that's a packing material, my lord.
I am obliged for the explanation.
The presence of wood wool around the bench where the fire probably started. And I also found wood wool in the front office here, in the reception area, and in this passageway leading to the storeroom.
Now, what is the significance of the wood wool?
The significance? Well, you see, that was how the fire was spread. The supposed cause of the fire was the deliberate overheating of a piece of electronic apparatus. Now, if you want a good fire, it's got to be fed. You've got to give it something to burn. Otherwise, it's likely to go out. Now, wood wool is an ideal arsonist medium. It's a very common material. It's used in a lot of factories. It burns beautifully.
Now, you said there were two things that suggested arson. What was the second?
Yes, the comments of the officer in charge of the fire, there were certain things about the course of the fire which he felt were unusual.
What things were they?
It was the pattern of the fire, the way in which the fire progressed, as if it were following a trail of inflammable material.
The wood wool, in fact.
Yes, madam.
We may take it then that, in your opinion, you're quite clear in your own mind that this fire could not have been an accident.
Almost certainly not.
You mean you're not 100% sure, Mr. Hewlett?
No, my lord. It's very rare in my experience when it comes to fires that you can be sure of everything. I'm 80% certain it was arson, but I'm sure there's no fire inspector prepared to be more definite than that.
Thank you.
Divisional Officer Hewlett, are you an expert on electronics?
No, sir.
What? But you said, did you not, that the probable cause of the fire was, and I quote, deliberate overheating in a piece of electronic equipment?
Oh, yes, well, I was quoting from Dr. Preston's report.
The electronics expert, my lord, his report is in the second bundle of
Yes,
documents.
yes, I have it.
But since, as you say, you are not an electronics expert, how can you judge the correctness of Dr. Preston's report?
Well, since Dr. Preston is an acknowledged electronics expert, I presume that he would know what he was talking about.
Yes. That's not the only presumption you made.
How do you mean, sir?
The question of wood wool, Divisional Officer. Because you found the presence of charred remains in the laboratory, you presumed it was there to feed the fire.
Well, why else would it be there?
It is a packing material, Divisional Officer. Perhaps they were unpacking or packing some item of equipment.
Well, why should it also be in the reception area and in the office, etc.?
Perhaps it wasn't.
Oh, but it was, sir, because I saw it.
Perhaps it wasn't originally.
I don't understand you, sir.
Neither do I.
I will explain, my lord.
Please do.
Divisional Officer Hewlett, putting out a big fire is a pretty messy business, isn't it? You know, what with gallons of water being squirted here and there, hoses everywhere, firemen stamping in and out.
Yes, sir, it is a messy business.
So messy, in fact, that the wood will, charred or not, could have been tramped in on the firemen's boots, spread around the factory from one end to the other.
No, not in those quantities, sir.
Are you sure?
Reasonably.
100%?
No, sir.
But you do agree that the presence of the firemen could have disturbed the scene of the fire?
Yes, sir.
Disturbed the evidence on which you based your report?
Well, it is possible.
Yet you still insist that the cause of the fire was arson.
Well, in my opinion, sir, there was sufficient evidence to suggest that the cause of the fire was arson.
Well, could it have been caused not by electronic means, but accidentally by something very simple, like a cigarette end?
Yes, sir, that is a possibility, and that is why we can only ever be 80% certain.
I see. Divisional Officer Hewlett, do you hold a degree in science? You know, an MSc, BSc, that sort of thing.
No, sir. All I have is 24 years practical experience with fires. I have attended courses at the Fire Services
Do you,
College.
Divisional Officer, have any scientific qualifications at all?
No, sir, just experience.
Thank you. No further questions.
You have 24 years' experience in the fire service,
Correct, madam.
and you've seen many fires that were started deliberately.
Oh, yes, madam. Quite a lot of suspected arson.
Suspected?
Yes, my lord. You see, arson is very difficult to prove. It's very rare in my experience that you will find a Home Office fire inspector like myself who can go into that witness box and say with sufficient certainty that he's reasonably sure that the fire was started deliberately.
Well, why is that?
Because, my lord, you see, the fire itself destroys much of the evidence of the arson. The arsonist depends on it. In this case, for example, if the arsonist had not been so ingenious electronically and yet at the same time so crude in the way that he tried to spread the fire...
Oh, by using the wood wool.
Yes.
Yes.
Yes, I mean, it's not a very clever touch at all, that, really. But if the arsonist had been more experienced, then I would not be able to stand up in this court and swear as to the probable cause of the fire.
As you are in this case.
Yes, madam.
So, in your opinion, the probable cause of the fire at Scott Specialist Electronics was arson?
Yes, madam.
And in your opinion, the fire was started deliberately by electronic means?
Correct, madam.
You are Norman Trevor Preston of Millfield, Scattersgate, near Ilkley.
Yes, madam.
And you are a Doctor of Science, a Professor of Applied Electronics at Fulchester University, and a consultant to 2 major electronics firms.
That's right.
Now, Dr. Preston, you were called to the scene of the fire at Scott Specialist Electronics.
Yes.
And you made an examination of various items at the seat of the fire.
I did, and I took quite a lot of things away for subsequent laboratory testing.
What exactly did you find there?
The remains of an oscilloscope.
Yes, well, now, Dr. Preston, you haven't given evidence in my court before, so let me warn you that I dislike jargon.
Jargon?
Technical jargon of any kind.
My lord, an oscilloscope is the name of a piece of electronic equipment. There's nothing else I can call it.
Could you perhaps explain the function of the oscilloscope?
Well, I've got one in court, if I may be permitted to show it.
Yes, of course.
This is an oscilloscope. What it does is to display a picture here of time variation of voltages in a circuit. In other words, it draws graphs of voltage variation against time.
Does that mean anything to you, Miss Gibson?
Oh, yes, my lord, I think so.
You're very lucky. I must confess I found Dr. Preston's explanation quite baffling.
My lord, did you never do physics at school?
I did classics.
Well, that's the problem the technologist faces these days, my lord. Scientific illiteracy. Something should be done about it.
My lord, with respect, I don't think it matters greatly what an oscilloscope does. For our purposes, it's simply a piece of electronic equipment manufactured by the accused.
Oh, well, if you say so, Miss Gibson.
Dr. Preston, you said that you found the remains of an oscilloscope at the seat of the fire.
Correct. The outer casing had been removed and the equipment had been left on soak.
On soak?
That's to say, my lord, it had been plugged into the mains and switched on overnight.
Well, why not say so? I don't know about scientific illiteracy, but it appears to me that the English language itself is in some danger.
Would you look at the exhibits on the learned clerk's desk? Are they the remains that you found in the ashes?
Yes, those are the items. Yeah.
Now, Dr. Preston, is it usual for the casing to be removed when a piece of equipment is left on overnight?
It's quite a common practice, yes.
Now, what is the reason for leaving the equipment on so long?
To test it, to reveal any faults, to see if there's any drifting off of the parameters of the device.
Is it usual, then, to surround the equipment that's on soak, being tested, is it usual to surround that with wood wool?
Not unless you want to cause a fire, no.
And what would be the cause of that fire?
The transformer in the oscilloscope, if that overheated, the wood wool would start to smoulder, and in no time at all you'd have a very jolly blaze.
How can you be sure that the transformer would overheat?
By using an integrated circuit timer, my lord, one of these things.
And how would that timer be activated?
Through an acoustic transducer.
Oh, what?
A microphone, my lord. Perhaps your lordship would permit a demonstration.
In court?
Yes, my lord.
Well, demonstrate the whole process?
Yes, my lord.
Well, including the fire?
Yes?
Well, there should be no danger, my lord. And the court usher can stand by with a fire extinguisher.
A fire extinguisher?
My lord, the purpose of the experiment is to demonstrate an incendiary device. In other words, to produce fire.
Oh. Oh, well, in view of the technical nature of the evidence, yes, all right.
Could you bring in the model, please?
Well, now, I hope this is all going to be quite safe, Dr. Preston.
Oh, yes, quite safe.
I shouldn't like to be the first judge in English legal history to burn down his own courtroom.
No, no, my lord, there's no danger of that.
May I leave the box to superintend the demonstration?
Yes, very well. Perhaps we should have Divisional Officer Hewlett standing by with his men. Hey, Mr. Canty!
Yes, well, there we are. For safety, the outer casing has not been removed. The circuit timer has been attached to the transformer, and the acoustic transducer is wired up to the timer, and all this is loosely packed round with wood wool. So, we now put the oscilloscope on soak. That's the same, my lord. We plug the apparatus into the mains and leave it on. Can you all see?
Nothing's happening, Dr. Preston.
My lord, this is an incendiary device. We now have to activate it.
Oh, by means of the telephone.
Yes, indeed. Or rather, more precisely, by the sound of the telephone. It's the ringing of the telephone bell which activates this device. Now, let me show you. The bell rings. The acoustic transducer activates the timer, which in turn permits the transformer to overheat.
Oh, Dr. Preston, still nothing is happening.
It will, my lord, it will.
When?
Any minute now. We have to allow the wood wool time to smoulder.
I see no sign of smouldering.
Patience, my lord.
Oh, Dr. Preston, we've got a great deal of ground to cover in this trial.
No, please, my lord.
Oh, very well. Something's burning.
The case of the Queen against Scott will be resumed tomorrow in the Crown Court. The fire at his small electronics factory proved very profitable for Hugh Scott, an ex-RAF officer. His factory was insured for £135,000. Only later, when the authorities investigated the cause of the fire, did questions arise. Was the fire at Scott Specialist Electronics deliberate or accidental? The case continues at Fulchester Crown Court today.
Now, let me see if I understand this, Dr. Preston. All the accused would have had to do would have been to telephone the factory at, say, midnight. The noise of the telephone bell would have activated the incendiary device, and 2 hours later, the transformer inside the oscilloscope would have overheated, causing the wood wool to smoulder and burst into flame.
Yes, madam, that's it precisely.
Now, in your opinion, would someone of Mr. Scott's background, the RAF, etc., would he have had sufficient electronic knowledge to have built this device?
Oh, yes, it'd be very simple for him.
And would the various parts of the device be easily available to the accused? Timers, for example.
Yes, particularly so in this case.
Why is that?
I found a couple of boxes of circuit timers in the factory storeroom, or rather what was left of it.
Thank you, Dr. Preston.
Dr. Preston, what about the acoustic transducer, the microphone, my lord?
Yes.
Were there any of these in the storeroom?
No, sir.
Are they difficult to obtain?
Good heavens, no. Any well-known supplier of electronic and radio spares would probably have a variety of transducers in stock.
What about timers?
They're equally common, no problem getting your hands on those.
Tell me, Dr. Preston, would it require an advanced electronic knowledge to produce this device?
It depends what you call advanced.
Well, could a BSc in electronics build it?
Oh, good heavens, yes.
What about someone with lesser qualifications, say an A-level physics?
Yes. In fact, anyone with basic electronic knowledge who takes one of those magazines on amateur radio would have no difficulty in building this device.
An intelligent teenager could do it, in fact.
Yes, indeed.
Now, what about Mr. Scott's employees? Was there anyone there who, in your opinion, who had sufficient knowledge of electronics to build this device?
Well, it would depend how long they'd worked there. It would depend what they worked on as well. I mean, you wouldn't expect a typist to know much about circuit timers and acoustic transducers.
But what about the men involved in building and testing these oscilloscopes?
Oh, yes, I imagine they'd have the knowledge.
How many men actually worked on this equipment?
About 30 men, I believe, my lord.
And any one of them would have had the knowledge to build this device?
Yes, I suppose so.
Oh, come, Dr. Preston, you said, did you not, that an intelligent teenager could build it?
Yes. All right, I should imagine that any one of the 30 men would have the knowledge to build this device.
Did you find anything in the remains of the oscilloscope, anything, in fact, that could directly connect Mr. Scott with the device that started the fire?
Well, he didn't leave his calling card there, if that's what you mean. But then he wouldn't, would he?
Dr. Preston, in other words, you are saying there was nothing that could directly connect Mr. Scott with the incendiary device?
If you want to put it that way, no.
Yes, I do, Dr. Preston. Thank you. No further questions.
Dr. Preston, you say you found no evidence in the burnt-out remains to connect anyone, Mr. Scott, or any of his men, directly with this incendiary device?
No, madam.
But then, would you have expected to?
No, madam. Everything was so buckled and badly burnt, it would have been a miracle if I'd found anything.
Oh, so what you're saying, then, is that in your opinion, this is a device designed to start a fire?
Oh, yes.
And that Mr. Scott, as well as others, had sufficient electronic knowledge to build this device?
Yes.
Thank you, Dr. Preston. I have no further questions, my lord.
Thank you. You may leave the witness box, Doctor.
Thank you, my lord.
Now, the last witness for the prosecution is Mrs. Deborah Todd.
Deborah Todd, please. What is your religion?
Church of England.
Take the Bible in your right hand and read aloud the words on this card.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
You are Mrs. Deborah Todd of Flat 9, Haywain Court, Fulchester.
Yes.
And you are divorced?
Separated, awaiting divorce.
You have children?
One, a small boy.
And you are employed as secretary to the accused?
Mr. Scott, yes.
How long have you been his secretary?
About 3.5 years.
And how was the business doing when you joined the firm?
Oh, very well indeed.
How many men did Mr. Scott employ?
About 65, I think. I can't remember now. Anyway, he was always on the lookout for extra staff.
And did business continue to boom for Mr. Scott?
Well, no, about 16 to 18 months ago, I think, things began to go wrong.
What happened?
Well, there was a fall-off in orders, and we didn't seem to be able to get much new business.
And did he have to lay off men?
Yes, he had to cut the staff right down.
Now, was Mr. Scott a practical man?
I don't know quite what you mean.
Oh, well, did he seem to like working with his hands, working on the equipment?
Oh, Oh, yes, he was always in the workshop or the laboratory. He always seemed to have a screwdriver in his hands.
So he was capable of building and designing all kinds of electronic gadgetry, you'd say?
No.
Well, yes, he was always tinkering with something new.
When the firm started to do badly, about 16, 18 months ago, I think you said, did Mr. Scott seem depressed at all?
Well, of course he did. He wasn't overjoyed at the thought of the business losing orders.
Did he ever talk of giving up the business?
Once or twice.
What exactly did he say?
Well, just that he wished someone would take the firm off his hands.
Did he mention any specific purchaser?
No.
And when was he saying these things? About 18 months ago?
Yes.
Do you know, then, that about that time when he was saying these things about wanting to sell, he increased his fire insurance?
Yes.
From 95,000 to 135,000 pounds. And did he tell you why?
No.
Did he ever discuss this matter with you?
No.
Are you sure?
Yes.
But you must have typed the letter to the insurance company.
Perhaps I did. I can't remember.
Yes, well, apart from saying that he wished someone would take the business off his hands, did he ever say he wished anything else would happen?
I can't remember.
Now, think, Mrs. Todd, think. I have your statement to Detective Inspector Owens here, remember. Are you sure?
Well, he said he wished he could put a match to the whole place.
And how many times did he say that? Once? More than once?
He didn't mean it.
How do you know?
Well, it was a joke.
How do you know?
Well, because he said it in a joking manner.
Well, how many times did he say that?
Well, 3 times I can remember. But I know he didn't mean it seriously.
Are you telling the truth, that you thought it was a joke?
Well, I know I didn't tell the police it was a joke. Well, I've had time to think since then.
To think of what, Mrs. Todd?
Well, I know he didn't mean it seriously.
You keep saying that, Mrs. Todd, and yet in your statement to Detective Inspector Owens, you never suggested that Mr. Scott was anything but serious.
Well, I should have done.
Well, if it was true, yes.
Well, it was.
Well, why didn't you say so at the time in your statement?
Well, I was nervous then.
Why?
Being questioned by the police.
Were you suggesting that the officer deliberately attempted to intimidate you?
Oh, no.
Well, then why were you nervous?
Well, I'd never had to make a statement to the police before.
Oh, you found it a frightening experience?
A bit.
I see. Yes.
Mr. Scott did make these remarks to you about wanting to set fire to the factory.
He didn't mean it.
How can you tell?
Because I know him very well.
Yes, how well?
Oh, stop this.
Mr. Scott!
She's harassing.
Sit down and be quiet.
Mrs. Todd, when was the last time Mr. Scott said these things about wanting to burn down his own factory?
About 3 weeks before the fire.
Yes, and how was the business doing then? Had things improved?
No.
They got better? Worse?
Well, we'd just lost an order for timers for a chemical firm. I don't think he was very pleased about it, that's all.
And 3 weeks later, Scott's specialist electronics was burnt down deliberately.
But not by Mr. Scott.
But then by whom?
I don't know.
Well, did you at any time hear anybody else say that they wanted to burn down the factory?
No.
Thank you, Mrs. Todd.
Now, Mrs. Todd.
My lord,
there are...
could I have a word with my counsel for a moment, please?
What? Oh, yes, very good.
Oh, thank you, my lord.
Yes, what is it? I don't want to question any further. What is it? Why give you interest? I'm paying you the money. Don't bloody do it. All right.
My lord.
Yes, Mr. Kent.
May I request a brief adjournment?
That won't be necessary.
Well, that is for me to decide. What is the problem?
My client doesn't wish me to cross-examine this witness, my lord.
Oh, no, Mr. Scott, you'll be well advised to leave the conduct of your case to your counsel.
It's my case, my lord. My counsel will conduct it my way or not at all.
My lord, I see no alternative but to...
Yes, Mr. Scott, I am going to have a brief adjournment to enable you to discuss with your counsel the conduct of your case. And I advise you very strongly to listen carefully to what Mr. Canty has to say.
It's my case.
We will adjourn.
All stand.
Be lawyers.
Now, Mr. Canty, what is the position?
My client wishes to conduct his own defense, my lord. I am therefore retiring from the case.
Oh. This is most regrettable. I am willing to consider a further adjournment to enable you to discuss the matter again with your client.
Ex-client, my lord.
My lord, I don't think any useful purpose
Yes,
will be
just a
served
minute,
by
Mr. Canty. Mr. Scott, this is a most unwise decision you are making.
Well, that's as may be, my lord, but it's my decision and it's final.
I beg you to reconsider it. No? Very well, so be it.
I regret the situation, my lord, but I have no alternative.
No, thank you, Mr. Canty. Well, now, let's get on. Mr. Scott, do you wish to remain where you are, or would you prefer to come down into the body of the court?
I'm quite happy here, my lord.
All right, well, now it's your turn to cross-examine this witness.
Thank you, my lord. I have no further questions of this witness.
Oh, I don't think you quite understand the situation.
I do, my lord, perfectly, and I do not wish to subject Mrs. Todd to further harassment.
No, you see, Mr. Scott, Mrs. Todd has been called as a prosecution witness, and under examination by Miss Gibson, she has made some statements which, it must be admitted, are damaging to your case.
I realise that, my lord.
Well, if you dispute any of these statements, you would be well advised to cross-examine the lady, if only on matters of detail.
But I don't want to. As far as I'm concerned, she can leave the box now.
Oh, not until I say so, Mr. Scott.
I don't want to cross-examine her.
No, but I have some questions to put to her.
I don't want her to be questioned. Let her leave the box, please.
Not until she has answered the questions from
My
you.
lord, I
Oh,
must...
sit down! Mrs. Todd, what precisely is your relationship with the accused?
I'm his secretary.
Oh, yes. Now, come now. His attitude to you is rather more than that of employer-employee. Are you also his friend? Are you his mistress?
Oh, my lord.
Scott, I will not tolerate any further interruptions from you. Now, you say you're about to be divorced.
Yes.
Case hasn't been heard yet.
No.
What are the grounds for the divorce?
The breakdown of the marriage. We haven't lived together for 2 years.
And you have interim custody of the child of the marriage?
Yes, my son, Simon.
Only child?
Yes.
Yeah, how old is he?
7.
You were married then quite young.
Yes, I was married at 17.
When did the marriage start to break up?
About 5 or 6 years ago now.
Just about the time you went to work for Mr. Scott?
Oh, there's no connection.
Oh, yeah. Now, what is your husband's attitude to this divorce?
I don't know.
Well, I mean, is there some woman he wants to marry?
I don't think so. Tony's a very possessive person, that's all.
Does he intend to apply for custody of the child?
Oh, he's no reason to, my lord. I'm a good mother. I earn good money as a secretary, more than Tony does himself. Simon doesn't want for anything.
Yes, but Mrs. Dodd, if some scandal were to attach to your name, would your husband then dispute your custody of the child?
Well, Tony doesn't give up anything easily.
And is that the reason for Mr. Scott's conduct in this court today?
Well, he knows it would break my heart if I lost Simon.
I see. Yes, well, now let's return to the question of the fire. Generally speaking, how would you say that Mr. Scott got on with his employees?
Oh, very well. The office staff adored him.
No, I mean the male employees, Mrs. Dodd. I mean the men who worked in the laboratory, the workshops.
Well, I think some of them found him a bit difficult.
Why was that?
Well, he was a bit of a perfectionist, you see. Well, he was a marvellous craftsman, everyone said so, but he was used to service life. You know, giving orders and having them obeyed. Well, it's not that easy in civilian life, is it?
Is that why he refused to employ union labour?
Yes. Of course, he had to pay over the rates to get the men to work for him, but, well, he still didn't seem to get the discipline he wanted on the factory floor.
Would you say that his attitude was resented by his employees?
Sometimes. Well, he didn't like arguments, you see. Employees talking back. He couldn't cope with it. He used to lose his temper and shout, and they used to shout back. Well, he's not a difficult person, really, once you get to know him.
You see, Mrs. Todd, what I'm trying to find out is, was anyone at work sufficiently angry with Mr. Scott to burn down his factory?
Quite a lot of people.
Who?
Well, any of the men that he'd had an argument with.
Oh, come now, Mrs. Todd. I mean, you don't burn down the factory unless you're a psychiatric case just because the boss shouts at you. If you did, half the country'd be permanently ablaze.
But he was always having rows with the men.
Yeah. Now, on the night of the fire, Mr. Scott was in London.
Yes.
Why did he go there?
Business.
What business? With whom?
I don't know exactly.
Didn't he tell you?
No.
Was that unusual?
No.
Did he often make these trips to London?
About once a month.
Anything unusual about this trip?
No. He stayed at the Edwardian, which he usually does, and he phoned me when he arrived, which he usually does.
Well, when he telephoned you, didn't he mention the business?
No.
Why did he seem worried, upset or anything?
No.
Now, what about his solicitor, Mr. Broom, being with him? I mean, did Mr. Broom often go on these trips to London with him?
Not often. Mr. Broom had gone to London with him once or twice in the past.
Yeah, I see. Thank you, Mrs. Todd.
My lord, may I be permitted to re-examine this witness?
What? Oh, very well.
Now, Mrs. Todd, Mr. Scott told Inspector Owens that he tried to phone a woman friend in Ealing. Do you know her?
No.
Did you know that Mr. Scott knew any women friends in Ealing?
No.
So were you surprised to know of this lady's existence?
Mr. Scott and I aren't engaged or married. He doesn't owe me any explanation of his past.
What about his present?
Well, if you wants to look up an old friend.
Ah, you think this lady is an old friend of Mr. Scott's?
I don't know. Anyway, it's none of my business.
Oh, now that's a very unusual and refreshing attitude,
I can't
Mrs.
help
Todd.
that.
On the other hand, you still haven't answered my question. I asked if you were surprised to know of this lady's existence.
Well, surprised is putting it a bit strongly. I just didn't know he knew her, that's all.
Well, had you any reason to think that this lady was from Mr. Scott's past?
I never asked.
Hasn't he told you?
I didn't ask him.
No, well, do you know, then, that the phone number Mr. Scott said he dialed was that of a bank?
A bank?
Yes, a bank in Ealing.
Perhaps he mistook the number.
Oh, perhaps. On the other hand, it's a nice, safe number to say that you phoned around midnight. No chance of anybody answering.
Well, that's hardly a question the witness can answer, is it, Miss Gibson?
No, it was more in the nature of an observation than a
yes,
question,
well, your final
my lord.
speech to the jury is the time for observations. Just get on with the questions.
As your lordship pleases. Mrs. Todd, are you in love with Mr. Scott?
Do I have to answer that?
Yes, I think you do, Mrs. Todd.
I can't.
My lord.
Scott, if you wish to remain in this court at all, be silent. Now, please answer.
You are in love with Mr. Scott?
Yes. Yes.
You hope to marry when your divorce comes through?
Yes.
Now, have you, Mrs. Todd, in the course of your evidence, been attempting to whitewash your lover?
No.
Thank you, Mrs. Todd. I have no further questions, my lord.
Thank you. You may leave the witness box.
Oh, thank you. Can I stay in court?
Yes, of course, over there.
That, my lord, completes the case for the prosecution.
Very well. Right, Mr. Scott, you can present your case.
Thank you, my lord. Now what exactly do I do?
Well, you present your case. Produce your evidence.
Well, I haven't got very much.
Well, I told you it was a mistake to dismiss your counsel.
Yes, but I did it, and I would do it again. Now, how do I go about presenting my case?
Well, you can either come to the witness box and be sworn, or you can make a statement unsworn from where you are in the dock.
Right, thank you. I'll be sworn.
Just a minute. It's not quite as easy as that. I must warn you that once you are sworn, then learned counsel for the prosecution is entitled to cross-examine you. But if you choose to remain where you are and make an unsworn statement from the dock, you cannot be cross-examined.
Very well, I'll be sworn.
All right.
What is your religion?
C of E.
Take the Bible in your right hand and read aloud the words on this card.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Now, you are Hugh Dennis Scott of 9 Ravenswood Court, Fulchester.
Yes, my lord.
And you are Managing Director of Scott Specialist Electronics, Alamein Way, Fulchester Industrial Estate.
Yes.
All right, carry on, Mr. Scott.
Yes. Well, first of all, let me say, I did not start the fire that destroyed my factory. I didn't plan it, I didn't build or set up any incendiary device, and I don't know who did. I won't say the idea of setting fire to the place hadn't occurred to me on many an occasion. It had a certain appeal, well, as I'm sure it does to most small businessmen. Most of us have a, what do they call it, a love-hate relationship with our businesses, but we stand by them, we have to. You see, I started Specialist Electronics the year I left the RAF. That was 8 years ago. I sank my gratuity and every penny I could beg or borrow, which wasn't a lot, but I sank everything into SSE. I picked those initials rather carefully. I wanted something that had a bit of a ring to it, something like BBC or GEC or ICI. Well, perhaps SSE hasn't got all that much of a ring, but it sounded quite good to me. My lord?
Yes, Mr. Scott?
Could you prompt me from time to time?
Prompt you? What do you mean?
Give us the nudge every now and again.
The nudge?
Yes, well, tip us the wink when I start to bore everybody. Ask me questions, keep things going for me.
Well, it may come as a surprise to you, Mr. Scott, but judges, like umpires and referees, are supposed to be impartial.
Well, I don't see how you can be impartial about me.
I don't understand. What do you mean?
But I don't know anything about the law, and Miss Gibson does. I don't call that fair. And there's no way you can be impartial about that, surely.
Oh, I can try, Mr. Scott. I can try very hard. Anyway, it was your decision to defend yourself.
Yes, but I was trying to protect someone. I didn't realize what was involved. I could go to jail for 10 years.
Yes, Mr. Scott.
Well, made a right cock-up of things, haven't I?
You were telling us why you chose the initials SSE for your firm.
Oh. Yes, well, they did look quite impressive on the letter heading. Look, there are one or two things I would like to say about motive. The prosecution's been going on about money being the motive as if I stood to make a fortune out of this fire. It just shows how much these legal eagles know about the real facts of business life. I mean, okay, so I owed the bank 70, 80,000, but my insurance was only 135,000. Now, by the time I've paid everybody off, settled all the outstanding debts, well, I'll be lucky to come out with 30,000 to my name. Well, that's not enough to start a business on nowadays, certainly not in the electronics field. It's barely enough to buy a house. And as for this nonsense about a so-called electronic device, well, I ask you, it is pretty primitive. We've been playing around with acoustic transducers and circuit timers for years. It's mission impossible stuff. Now, I am a damn good electronics engineer. You ask anyone. I may not be tops in the personnel field, but when it comes to the technical side of things, I know my stuff. And well, if I'd wanted to burn my factory down, I could have come up with a device that would have given your so-called experts something to think about. Not this rubbish. Oh, it's no good, my lord.
What isn't?
Well, you might as well pronounce sentence now. I'll never make a barrister in a million years. I'm not convincing anybody.
The case of the Queen against Scott will be concluded tomorrow in the Crown Court. Fire. It destroyed a small electronics factory on Fulchester Industrial Estate. It should have brought the managing director of the company, Hugh Scott, £135,000 in insurance. It didn't. Hugh Scott is on trial today in the Fulchester Crown Court. The charge is arson. He has dismissed his counsel and is defending himself.
My lord? My lord?
Yes, Mr. Scott.
I've been thinking...
Oh, yes?
...about my position. It's not very good, is it? As I said yesterday, I'm no advocate. I'm no good at putting my case. But if you would bear with me, I mean, if the court would bear with me, there are one or two other points I would like to make before the prosecution makes mincemeat of me.
What you mean is that you feel you haven't completed your evidence.
No, that's it exactly, my lord.
Well, bearing in mind that the time of the court is not limitless, please continue.
Thank you. Last night I made one or two notes. Is it all right if I refer to them now?
Yes, please do.
Thank you. My lord...
Yes?
If I wander off the point. You will stop me, won't you?
Oh, you may depend on that.
Right, well, here goes. Well, point one, as I said yesterday, I didn't start the fire that destroyed my factory. There's no reason to. There wasn't enough money in it. Look, at the time of the fire, I was negotiating with a chain of garages to supply a whole range of electronic testing equipment. Now, one or two contracts like that, and SSE would have turned the corner financially. But to do that, I need a factory, not a pile of cinders. Point number two, the night Larry Broom and I went round the Soho clubs, the night I was supposed to have made that phone call. Okay, so I made the phone call, but I was a little tight. I thought it would be nice to phone this woman I used to know. Well, have none of you ever tried to contact an old girlfriend? And do you always get the number right, particularly if you've had a few drinks? I got the number wrong. It turned out to be a bank in Ealing. It could just as easily have been a shop or an office or an all-night laundrette. Would that have made it any less sinister? Oh, yes, and lastly, the question of my labor relations. Well, I know I'm not the most popular boss on the industrial estate. But you can't do 14 years in the forces, man and boy, and expect to emerge as a sort of glorified shop steward come social worker. If I give an order, I expect it to be obeyed. If a man turns in a sloppy job of work, I'm not going to pat him on the back. I'm going to kick him up the... well, he's not going to get away with it. And consequently, I'm not loved. But I'm not out to win the popularity stakes. I'm there to see Scott Electronics turn out the best in electronic craftsmanship. Now, as I say, I'm not loved, and a lot of chaps would like to see me put out of business. The unions, for one. I pay the highest salaries on the industrial estate, but I will not have a union shop operating on my factory floor. My lord, I have one or two other points I would like to make, but I think I've talked enough for the moment. After my friend there has had her whack, I do get another bite of the cherry, don't I?
Yes, but only on matters arising out of the cross-examination.
Good. Well, that's me finished then for the moment. Your turn, my dear.
Oh, thank you, Mr. Scott. Now, how long were you in the Air Force?
14 years. I went in as a boy entrant.
What did you train as?
I trained in radar and wireless. I wanted to be aircrew.
Did you succeed?
Yes and no. I was training to be a wireless operator navigator when the medics grounded me.
Oh, why?
What they call tunnel vision. Evidently, I don't see as much as ordinary people on the periphery, the edges of things.
And this made you unsuitable for aircrew?
Yes.
So what direction did your career take then?
I went on an electronic engineering course.
Were you an officer by this time?
Yes, I had been commissioned by then.
What rank were you when you left the RAF?
Flight Lieutenant Engineering.
And how long had you been commissioned?
6 years, something like that.
Had you ever attended any courts-martial?
Courts-martial? Well, my lord, I don't really see what that's got to do with me setting fire to my factory.
I think I'm inclined to agree, Mr. Scott.
I do assure your lordship my question is relevant.
Very well, please answer.
Did you ever attend any courts-martial during your service with the RAF, Mr. Scott?
Well, one or two.
As prosecuting or defending officer?
Both. One is ordered to prosecute or defend, as the case may be.
So, in fact, Mr. Scott, you're not quite the legal innocent that you would have us believe. You have defended and prosecuted before.
Yes, but not in a proper court of law.
No, nonetheless, you are used to marshalling arguments, to presenting evidence, to putting together a case.
Yeah, but not in front of a judge and jury.
No, the setting may be different. The principle, the technique remains the same.
Well, it certainly doesn't feel like it.
Oh, I think you underestimate yourself, Mr. Scott. So far, I think you're doing very well. Very clever job of work. I particularly like the touch about your business being on the verge of turning the corner.
Well, it's true. If I'd got that contract to supply electronic equipment to this chain of...
To whom?
A chain of garages, Moore's garages.
Yes, and how many of Moore's garages were you going to install this equipment?
20.
And what was the contract worth?
£20,000. It would depend what we quoted.
Yes, how much do you owe the bank?
Around £70,000 or £80,000, something
And
like
what would your margin of profit have been on £20,000?
Well, that's hard to say.
10%, 20, 30, 40?
No, it would depend on how tight we would have had to have quoted.
Were there many firms after this contract?
One or two.
My information has it that there were 4.
Oh, possibly.
So that there was only a 1 in 4 chance of you having got this contract.
Well, I'd have got it all right.
Well, how do you know that?
I'd have made damn sure I did. I would have undercut everyone else.
And perhaps made no profit at all.
It would have kept the factory going.
But it wouldn't have solved the firm's cash problem, would it? You'd still have been in debt to the bank to the tune of £80,000.
No, but there would have been money passing through the account. Now, that's all the bank worries about.
If that's your idea of business finance, Mr. Scott, I'm not surprised you were in trouble with the bank.
Well, there were one or two other things. I was hoping to get a contract with a chemical firm to supply timers and several other
And would you have profit on them have paid off your £80,000 overdraft?
Well, no, but it would have been a step in the right direction.
It's just a step. You'd have needed a lot of other contracts, a succession of regular work to have kept going, wouldn't you?
Yes, but one isn't going to be sitting...
Whereas your fire insurance payment of £135,000 would have been sufficient to pay off the bank. You would have paid all your outstanding debts and been left with something to be going on with.
That's not how it was.
You could have done all this on the result of just one fire.
But I didn't. I couldn't.
Oh, what do you mean?
Don't you understand? I had invested too many years of my life into that firm to see it destroyed. I built it up from nothing, from scratch. I started out with a collection of electronic spare parts that I bought cheaply, 4 workmen and a girl typist. Now, within a year, I was employing 15 people. Within 3 years, I was employing 50. I worked my guts out for that firm, day after day, 7 days a week. Well, my marriage broke up because of that factory. My wife enjoyed being a service wife, but being a junior tycoon's grass widow wasn't her idea of fun. I sacrificed too much to that factory. And do you really think I would destroy what's taken 8 years of my life to build up?
Oh, yes. If what you were building was going to be taken away from you anyway.
Well, who's going to do that?
Your bank, your creditors.
I'd see them in hell first.
Oh, so you do anything to stop your business falling into their hands. You'd even set fire to it.
No, you're putting words into my mouth.
I hardly think so, Mr. Scott. Anyway, let's turn now to the night of the fire. What time did you leave the factory?
When it closed, 6 o'clock.
Were you the last person to leave?
I don't know.
You told the police that you were?
Oh, well, in that case, yes.
Yes, before you left, did you go into the laboratory?
No, I put
Are you sure?
Yes, I put some papers in my briefcase, locked my office and left.
So you don't know if there were any items of equipment left on soak overnight?
No, but there usually are some. It's the only way of testing equipment.
Yes, what did you do after you'd locked up the factory?
I turned on the burglar alarm, got into my car, drove to the station where I met Mr. Broom.
You travelled to London with Mr. Broom?
Yes.
And what did you do then?
We got a taxi to the hotel.
The Edwardian, yeah?
Yes, I usually stay there. We booked in, we had a couple of drinks and went out to dinner.
When did you go to the clubs?
Around 11:30.
Yes, you went first to the Blue Giraffe in Dean Street.
Yes.
And what did you do there?
Do?
Yes.
We had a drink, talked, watched a strip show, chatted up a couple of
Did
girls.
you make a phone call from there?
Yes.
When?
Around midnight.
And who did you phone?
This woman I used to know.
Yes, what woman? What was her name?
Josephine Bradley.
Have you known her long?
Well, for some years.
You seen her recently?
No.
When had you last seen her?
Oh, about 6 years ago.
And you did have her address?
I used to.
You used to?
Yes, I lost it. I mean, 6 years is quite a long time.
Then how did you know where to phone her?
I thought I remembered her number.
You thought you remembered her number?
Yes.
After 6 years?
Oh, look, I mean, one goes into a club, one has a drink, you talk about old times, old friends. I thought it would be nice if Jo could join us for a drink, or we could go to her place.
To Ealing? After midnight?
It's not the dark side of the moon. There are taxis, streetlights, even people around at that time of night.
In my experience, I've always found that sarcasm is self-defeating.
Well, it was a bloody silly question, my lord.
Mind your language.
Sorry, my lord.
Mr. Scott, you are asking the court to believe that you proposed to turn up to see Miss Bradley.
Mrs.?
Mrs.?
Yes, she was divorced when I knew her.
Oh, well, then you proposed to turn up to see Mrs. Bradley after midnight in the company of Mr. Broom.
No. That's why I telephoned first, to find out. But there was no reply.
Because it was a bank.
Yes.
Now, what was the purpose of his trip to London, Mr. Scott?
Business. I was going to see a merchant bank.
Not in Ealing.
No, a merchant bank in the city.
No, which one?
Mullins and Scrivener. They're in Old Jewry.
When was your appointment for?
The next day.
The day of the fire?
Yes.
Why did you take Mr. Broom with you?
Oh, well, I thought I'd stand a better chance if my solicitor was with me, and Larry knows quite a lot about my business.
You'd stand a better chance of what, Mr. Scott?
Of raising money.
But you already had an overdraft of £80,000.
Yes, I just needed a few thousand to tide me over, a short-term loan.
Were Mullins and Scrivener sympathetic?
I never got to see them.
You never got to see them?
No.
But surely that was the whole purpose of your trip to London.
Yes, but that morning, whilst I was having breakfast in the hotel, I received a telephone call from the Fulchester police telling me about the fire. Now, there's no point going to see a merchant bank about a business proposition when your business is a pile of cinders, so I telephoned and cancelled the appointment.
Which you never meant to keep anyway.
That's not true.
The truth is, Mr. Scott, that your little trip to London served solely no other purpose than to provide you with a foolproof alibi. And you telephoned your factory from the Soho Club, thus triggering off the device which started the fire.
No.
Mr. Scott, you are the only person who stood to gain from this fire. Who else, I ask you, who else would have built and operated such a device?
Well, after working for SSE for a year, any one of my workers could have done it.
Oh, are you accusing your own workers? Are you seriously asking the jury to believe that someone who had worked for you, whom you had employed, would go to all the trouble and the expense of building and operating this device just to get even with you because you shouted at them?
No, I'm not saying it was one of my workers.
No, then who are you accusing?
No one specifically.
I have no further questions, my lord.
Oh, now, just a moment.
You wish to say something more, Mr. Scott?
Oh, yes, I do, my lord.
Well, I will remind you that you will have your opportunity to address the jury, and you have a witness to call.
Yes, Lawrence Broom.
Yes, so return the prisoner to the dock. Call Mr. Broom.
Lawrence Broom, please.
What is your religion?
Church of England.
Take the Bible in your right hand and read aloud the words on this card.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Now, you are Lawrence Gareth Broom of Betsykirk Cottage, Alcester Road, Fulchester.
I am, my lord. I am the defendant's solicitor.
Oh, yes, indeed.
Which must raise the question of privilege, my lord.
What's privilege, my lord?
Well, Mr. Scott, since Mr. Broom is your solicitor, any communication between you, verbal or written, on any matters pertaining to this case, are what is known as privileged communication. That is to say, Mr. Broom may not be questioned on these matters.
Yes, but I need his evidence.
Yes, just a minute. Mr. Broom may not be questioned on these matters unless you waive your privilege.
I'll waive anything you like, my lord. May I question Mr. Broom?
Now, I beg you to consider this very carefully. Once you have waived your privilege, then Mr. Broom may also be questioned by counsel for the prosecution.
I need Mr. Broom's evidence. I waive my privilege. All right, my lord?
Very well.
Now, Larry, will you please tell the court who arranged our appointment with Mullins and Scrivener?
I did.
Why?
I had reason to believe they might be interested in our proposition.
Yes. Now, you are familiar with the state of my business?
Yes.
Well, would you tell the court your opinion of my business prospects prior to the fire?
In my opinion, and in the opinion of one of my accountants, Scott's Specialist Electronics could have been made profitable again.
In other words...
All it needed was the injection of a little extra cash.
I'm sorry, in other words, it hadn't gone down the drain.
Yes. On the contrary, it was rescuable.
And lastly, who advised me to increase my fire insurance to $135,000?
I did. You had been underinsured.
Thank you. Your witness, Miss Gibson.
Yeah, Mr. Broom, you've been on business trips before with Mr. Scott.
Yes.
To London?
On occasions.
Yeah, did you go round the Soho clubs on each and every occasion?
No.
Had you ever been to a nightclub before with Mr. Scott?
Once, about 3 years ago.
Where was this?
In Batley.
Not in London.
No.
So you don't know if Mr. Scott makes a habit of phoning old girlfriends in the small hours of the morning?
No.
Was Mr. Scott drunk that night?
He was merry.
Merry, meaning cheerful, excited, happy, not staggering drunk.
Yes, he'd had a good few drinks. It's not easy to define degrees of drunkenness.
No, and had you been in Mr. Scott's company when he seemed drunker?
Yes.
Did he phone up any old girlfriends then?
No.
Thank you, Mr. Broom.
Mr. Scott?
Yeah. Larry, were you with me when I received news of the fire?
Yes.
Well, will you tell the court how I reacted?
Staggered. Appalled. As though you'd been poleaxed.
The reaction of a man who just burnt down his own factory.
Oh, my lord, I don't see how Mr. Broom can possibly answer
No,
that
neither
question.
do I.
I think I can safely say that it was my impression that Mr. Scott was as surprised to hear of the fire as I was.
That completes the case for the defense, my lord.
Well, thank you. You may leave the witness box. Well, I think that would be a convenient moment to adjourn. We will hear the final speeches after lunch.
Lord, members of the jury, the facts in this case are quite straightforward. The accused owned a factory, Scott Specialist Electronics, which was burned down in the early hours of the morning on November the 6th last. Now, the specialist evidence leaves little doubt that this fire was started deliberately by means of a complex and ingenious electronic device. You've seen the workings of this device clearly demonstrated in this court. Now, the case against the accused is equally straightforward. A few months before the fire, Mr. Scott increased his fire insurance. Now, this at a time when he was in considerable financial trouble. The insurance payment was enough to pay off his debt to the bank and to leave him with about £30,000. Not a bad profit, you might think, for the expenditure of a couple of pounds on parts, plus a trip to London with his solicitor. Now, this trip was, in fact, a blind designed to provide Mr. Scott with a foolproof alibi. However, there is one detail that is important. It has been shown to us that this fire was started by a telephone call. Now, in London, Mr. Scott made a telephone call, he says, to an old girlfriend, but that number has been proved to be that of a bank in Ealing. Now, it is my contention that Mr. Scott actually telephoned his factory, thus triggering off the device which started that fire. Unfortunate that he had not reckoned on the opinions of experts. Now, Mr. Scott, we are told, was unpopular with his workers. Any one of them, it is said, could have started this fire. But ask yourselves, members of the jury, why should they? I mean, what profit was in it for them? Why should anybody, in any case, want to put themselves out of work in this day and age simply to get even with their boss, who's probably insured anyway, who's bound to be insured anyway? No, members of the jury, that fire was a profit to one person and to one person only, to the accused. And it is your duty to see that he does not make that profit by bringing in a verdict of guilty.
Yes, Mr. Scott.
My turn.
Yeah?
Thank you, my lord. Our members of the jury, I have here a whole speech all carefully written out. It's full of whereases and inasmuchases, and it's very impressive. The hell with it. I have only one thing to say to this charge. I didn't do it. It's not a very original line of defense, is it? I'm sure you've heard it before. But in this case, it happens to be true. I did not start that fire. In spite of the so-called experts and all the evidence, I didn't do it. And I don't know who did. Frankly, I didn't realize I had to provide an alternative suspect. I thought, in my simplicity, that I was innocent until proved guilty. Not that you think so, to hear the way the police and the prosecution have gone on. But proved, mark you. There is no proof against me. I mean, has the prosecution succeeded in tracing any of the electronic machinery to me? No. Did anyone see me with the oscilloscope and the timers? No. Did anyone see me spread wood wool around my factory? No. Did anyone see me dial Fulchester 61660? No. On every major point of direct evidence, there is quite simply no proof. Now, the fact is, I had recently increased my fire insurance. Why? As Mr. Broom has told you, I was underinsured. The fact is, I was in London at the time of the fire. To provide an alibi? No. To see a merchant bank, to raise money, to keep my business going. I mean, the fact is, my business was in trouble, but so is a vast majority of small businesses in this country today, and despite what the prosecution says, £30,000 is not a lot of money. It's certainly not enough money to risk the kind of scandal that would result and could destroy any future I might have as a businessman. So, in cold, hard, practical terms, my so-called motive just doesn't hold water, it doesn't stand up. And if my motive doesn't stand up, then where's the prosecution's case? Because that's all it's based on, you see. Motive. Oh, if I hadn't dismissed my counsel, you wouldn't have even bothered to listen to all this. You would have found me not guilty days ago, because that's what I am. Not guilty.
Yes, members of the jury, arson is committed by a person who, by means of fire, without lawful excuse, destroys or damages any property belonging to another, intending to destroy or damage any such property, or being reckless as to whether any such property would be destroyed or damaged. Now, there's been a great deal of talk in this case about this factory being the accused's factory. Well, it isn't. It belongs to a company. And if he did burn it down, then he had no right to. The alleged motive is, of course, that the accused, as the owner of most of the shares in the company, would ultimately benefit from any insurance monies received. Now, arson is a notoriously difficult thing to prove, but you may think that the prosecution has shown that the accused did have a motive. He certainly had the technical knowledge to set up this incendiary device, demonstrated so dramatically by Dr. Preston. And if you accept Dr. Preston's evidence, then this was arson. And what you have to decide is whether or not the accused set up the device and then made the telephone call which electronically triggered off the fire. Now, the accused hasn't made things any easier for himself or any clearer for you or me by dismissing his counsel and defending himself. But here I must tell you that the accused was mistaken when, in his address to you just now, he said that he had to show that someone else started the fire. That isn't so. The burden lies on the prosecution to prove to your entire satisfaction that the accused deliberately started that fire. If you are so satisfied, then he is guilty. If you are not, then he is not guilty. Will you now please retire and consider your verdict?
Prisoner will stand. Members of the jury, will your foreman please stand? Just answer this question, yes or no. Have you reached a verdict upon which you are all agreed?
Yes.
Do you find the defendant, Hugh Scott, guilty or not guilty of the charge of arson?
Not guilty.
You can join another jury when our cameras return to bring you a leading case from the Crown Court.